question for determination, and that is of the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and the exercise of its powers or functions shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, Sub-Article 11 requires that the holder of such office to have regard to public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So, based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are plethora of authorities on question of the competence of framing of charge sheet. So I'll not go into that. I'll go into Section 134 of the Criminal Procedure Code that states, and I quote, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense. End of quote. I'm not going to read Section 176. I've elaborated the provision of that Section 137. So, courts, as I've stated, has also considered what is essential in framing of a charge. In the often cited case, in the realm of framing of charges, the case of Sigilani versus Republic, 2004, 2 KLR, for 80, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test whether a charge sheet is fatally defective or incompetent. I will not cite it. So indubitably, therefore, a charge must therefore be clear and easy to understand. In as far as possible, the use of technical language in a charge sheet ought to be avoided. An accused person must be accorded an opportunity to understand what he or she is facing before court. I've cited the authority of Besman Katwenge Wafula versus DPP, that is petition number E045. So I'll go to the finality of the finding of the court. So in document, I find that the requirements of a properly drafted charge sheet has been surmounted by the state. I find also on the face of the charge sheet, I'm of the conscientious view that the suspect will be able to fathom and adequately discern and be able to prepare for her defense. So the finding of this court is that I'll direct the suspect to take plea in respect to the charge sheet that has been presented before court.
Yes, Your Honor. We have recent hearing and we are well guided in regard to a number of issues that you have raised, and others will appreciate that we read the full text of the MOU. However, the defense, if you like, make an application to defer the taking of the plea today. Yes, to enable the defense team to get the views of the Constitutional Committee. On a number of issues, Your Honor, we need not be emphasized, and as we argued last time, still with the suspect's team holding her guard, because he's entitled under the Bill of Rights not to say anything to the charges, to confirm whether she had statements or not. To make a reference so that the Constitutional Court is in a position to define the parameters of the constitutional privilege and the license of a member of Parliament. When you are addressing your constituents' grave issues as a breakdown of law and order, there have been property destroyed, lives have been lost, and I think a number of issues are very clear, even from the ruling, that she's a member of Parliament, that is not in contention, that she takes a much wider license in terms of her freedom of expression at Article 33, as read together with the parliamentary statutes and the separation of power doctrine. I'll have my colleagues here assist further, but the only thing I may mention, so that we ask you for a short time limit. We propose 14 days to be able to go to move the Constitutional Court. We have to appreciate that we are also going on vacation, but so we may not be sure whether we will get a date as fast as possible. The only thing I will mention is that we need to seal this license in terms of even a judicial officer. Tomorrow could be arraigned on the basis of a judicial decision or a statement made in court. I do think that you think it's far-fetched, but we are living in very uncertain times, and I think it's good to mention that, so that we appreciate the doctrine of separation of powers and the license that goes with that office of a member of Parliament in regards to our constituents' issues involving security.
Allow me one or two.
Thank you, my other friend is that.
I think what you can agree how many?
Yes.
Just for purposes of order.
Yes.
But if you have an advantage of going through my ruling,
Yes.
even in a bit I have indicated the manner and the mode of arrest.
Yes.
I have castigated the agencies for the way the arrest was done.
Yes.
So it's holistic. On the question of, and I've explained it to the Supreme Court, I've cited that case of Halu.
Yes.
On Section 33, in as much as I would be really wanting or urging to make such determination, but my hands are tied.
Yes.
We are appreciating that.
Yes, you actually want to address you why your hands
but-
are not tied. And at the fullness of time, you grant us the stay. And the the High Court will be able to set that record clear. I am of the convinced opinion that your hands are not tied and that Section 8 does not limit you. And that is why you honor the justification for the stay. But let my learned friends answer.
So how many of you will argue?
We are only the four of us. So if Mr. Muriu goes first, then my learned friend goes, then I'll sum up.
Thank you. With the utmost respect, Your Honor, we are dealing with an extremely fundamental issue touching on Article 33, the freedom of speech. Going by your dissection, both under the Constitution and the civil procedure, this matter is purely a Bill of Rights issue. And therefore, it requires a considered interpretation on what constitutes a crime by a citizen of this republic, and also what constitutes a crime by an elected member of parliament, or an elected member to represent people in various legislative bodies. Your Honor, this is informed by the fact that the role of an elected member is, number one, representation. Number two is legislation. And number three, Your Honor, is oversight. And therefore, when a member of parliament makes a statement on the state of affairs in his constituency, and then that statement is criminalized, Your Honor, I would say without any hesitation that if that's the case, we no longer have a country. And therefore, that's when I argue kindly to allow us to have that interpretation in the international court, and we defer the taking of the plea of the accused. Thank you, Your Honor.
Your Honor, your kind permission, my name is Mansa. Your Honor, we